Okay, let's start with this very strange year because there were 60 cases decided. That's low, and it's been low. We've discussed that. It's been low. 8,000 cases were considered. So do you know what that means? You know what that means? When your neighbor gets in a dispute with you and he says, I'm sick of you, I'm going to take you to the Supreme Court, you should say, I doubt it. Because in this case, only 60 cases out of 8,000 went, and the Supreme Court needs to hear your case. It's granting a certiorari. They decide to hear your case. But what did happen this year, and we need to talk about this urgently, is what's now called the shadow docket. Now, we never really made a big deal out of the shadow docket. Those are emergency appeals to the Supreme Court. They do not receive signed opinions. There is no oral argument. There are no briefs. It's like on the fly. It goes fast. And the Trump administration's sweeping executive orders inspired a record number of cases brought by the Department of Justice. I think 17 or 18 cases went up as emergency appeals that the Supreme Court ultimately heard. And so this fast-tracking method has done something that we had not actually seen before. And let's start with Neal. I mean, how precedential is this? Is this a good thing? The Supreme Court is known for being plodding and incremental. And this seems fast track. Isn't that good? Fast track? Or is this something that is emanating out of this particular court and this particular president?
So thank you, first of all, for having me. It's a real privilege to be on this panel and with you. I think it's generally not a good thing. So let me just explain what this is when we talk about the shadow docket or the emergency docket. I'll just give you one of my cases. So Kathy Harris is an official. She runs the Merit Systems Protection Board, which is an agency set up by Congress in 1978. And when Congress set it up, it said the president can't fire the head of it without good cause. And so that's by law, by statute. So Trump comes in and just fires her without good cause. He doesn't even try and say good cause. He just fires her, and he says the statute's unconstitutional. We then go into court defending her and saying, no, Congress passed this law. It's obviously not unconstitutional. We win in the trial court. And so what the trial judge says is, we're going to stop this person, Kathy Harris, from being fired. And we're going to enjoin that. So it's a legal order preventing her from being fired. The Trump administration takes an emergency appeal to the Court of Appeals saying, stop this, fire her. The Court of Appeals says no. The full Court of Appeals says no, 7-4. It then goes up to the Supreme Court in an emergency application by the Solicitor General, and the Supreme Court says, we're not going to decide the merits now, whether she should be fired or not, but it is harmful to the president not to have his people in, and so we're going to let her be fired and let Trump appoint someone else. So that's what the shadow docket is in practice, is that's just involving one person. Sometimes you have shadow docket cases, as we'll talk about birthright citizenship, that involve, whole big swaths of society.
But there were things like, for instance, the case involving transgender serving in the military. The number of the deportation cases, they weren't really deportation cases. They were stopped. The merits were decided. This was, remember, the Venezuela number. I think there's a temporary status. There was the special protections by the Biden administration for Nicaraguans and Haitians and Cubans. All of those cases were initiated by the executive orders. And then all of a sudden, the Trump administration went in. And then in the end, for the most part, with the exception of, was it Kilmer Abrego Garcia, right? That was one case where the Supreme Court said, this is the gentleman who was taken to Venezuela and brought back. So that was one case that Donald Trump didn't win, right?
So yes, so you're giving a bunch of examples, and let me just give you a little data. So when I was running the Solicitor General's office, I never sought one emergency application to the court. And indeed, over the 16 years of the Obama and Bush administrations, I think a total of 8 emergency applications were filed. Trump has filed 20 already in 6 months. It's a stark number. Now, what he would say is, well, Biden filed 19 over his 4 years. I'm 20 in 6 months. That's not that different. It is, of course, different. The administration isn't very good.
But wait,
at
Neal,
math.
I'm sorry, just be clear. Am I right that there's still way more than both George W. Bush and Obama did in 8 years each?
Oh, yeah, no.
Right? If you added all those years,
all those 16
Right.
years, you'd have 8 applications total.
the whole time.
Trump filed, that's in 16 years. Trump has filed in 6 months, 20. Biden filed 19 over his 4 years. So the number has been going up, but it is a reaction to, as you were saying, Thane, this large number of executive orders. And so the court gets into these positions where it's got to decide these things really quickly, as you note, without really extensive briefing and the like, and they decide it without really written opinions. And so, or very short opinions that don't give any reasoning. And so Justice Ketanji Jackson has been recently very critical of this practice, saying, look, we've got to give guidance to the country as to what our decisions say. The whole point of the Supreme Court is to have written decisions and that explain fully our thinking, and we're not doing that. And so that's the danger.
Right, but also your case was a case in which there's a lot of precedent that says Congress can pass a statute that says president can't fire people, create all kinds of restrictions on the president firing people. And they just, ignore that. I think they're going to overturn that precedent eventually, but they haven't. Well, we'll see.
All right. Oh,
Yeah, but this is, it's big both in terms of they're
Bill.
deciding all these cases without briefs in like a paragraph or two. But this is also a case in which, they're really getting ready to overturn precedent, long-established precedent, in like a paragraph or two, right? And it's part of the unitary executive, the idea that the president can do anything and court's not going to stop them. So these are really big deal cases.